Welcome to What's a Scenario with PLRB, where we explore claims and coverage scenarios relevant to insurance professionals. I'm Brendan McLaughlin.
Hey, Brennan. I'm Mike Brode.
I'm Tim Havler.
Tim.
All right, Tim, what's a scenario?
A scenario today. The named insured was a 100-year-old man who lived alone.
Oh,
His daughter came by often to help with cleaning, maintenance, and paying the bills.
it's nice.
One day, the father died of natural causes.
Oh, that's sad.
The daughter was the executor of his will, and she inherited the house.
Oh,
So she moved in and continued to pay all those same bills, including the premiums on that same insurance policy.
smart.
4 years later, there was a fire.
Oh,
So when the adjuster looked at the policy, the original named insured, that is the father, was still the named insured.
Right.
The daughter never changed the name on the policy, and the insurance company just kept auto-renewing it every year. Question: can the fire loss be paid on the policy, on a policy which is in the name of a deceased individual?
Ooh, fascinating.
But first, trivia time.
Yay.
all right.
Okay, who is the oldest person ever to live where there is credible evidence and documentation of it?
Wait a minute. Where? Who? What's the question, Tim?
Okay.
We got to guess how old they
narrow that
were?
one down a little bit for you. How old is the
Okay.
oldest person ever to live with good documentation behind it?
So we're not going like Old Testament Bible where people live to be like 200 some years old. We're going modern record keeping era. You're thinking
Modern record keeping era.
I don't want to be
Hello.
controversial, but yeah.
I'm just looking for a number.
Okay.
That'll be General Sherman. We learned that last time.
No way.
Yeah, very like 400 years old or something. No, I feel like people like someone lived to like be like 110 or something like that. I would have to say 110.
Ooh, Tim, I think I might know. We'll see. 116. I believe it was a Japanese lady.
I
Aha.
saw that one in my research, but it was one. A lot of these, there are questions about it, which is why
I'm right. I'm right.
Well-documented ones. But our answer,
yes,
you'll have to forgive my French pronunciation. It's a French woman. Jeanne Calment. Lived to 122 years old. Died in 1997.
Okay.
Now, I should note.
Please do.
Several years ago, a Russian gerontologist hypothesized that actually her daughter assumed her identity in 1934 to avoid taxes.
Aha.
But that's widely disputed, and generally, this is pretty well recognized that there's good documentation. And one more point of interest: she did smoke after meals.
Good.
But she quit at the age of 117.
Smart.
Okay, so the whole point of this death clause is think of how many times the policy uses the word you and your.
Right.
And then it explicitly says in the beginning, you and your mean the named insured as shown in the declarations plus the spouse.
Okay.
So if you have someone who's no longer living, who is referenced all over the place in the policy, including saying we will pay losses to you, named insured, it's kind of off. It's not, it's like the whole thing doesn't make sense anymore. All the duties imposed. Every time it says you, we don't know who we're referring to anymore. But like Mike just said, you can't really be canceling coverage the second someone dies.
Right.
Because there's a lot going on for the family and friends immediately after that death. It's unexpected. It's not planned for. They're going to have funeral arrangements, wills and trusts and assets and all this stuff. And believe it or not, the insurance policy is probably not the first thing on their mind.
Right.
So the policy builds this right in and gives a grace period. This
For
is the
4
death
years.
condition, which I will read now. If any person named in the declarations or the spouse, if a resident of the same household dies, the following apply. We insure the legal representative of the deceased, but only with respect to the premises and property of the deceased covered under the policy at the time of death. And
Okay.
again, the idea here is give the insured's family a grace period, let them get their affairs in order, and then once things calm down a little bit, then they can make sure that their insurance policy matches their actual situation at hand, whatever that is, because who knows where the house is going to, and who knows who's going to need insurance for that house.
Right. Good point.
Yeah.
How long is this grace period, Tim? 4 years?
Not quite 4 years. In the ISO forms, which is what we're going to be working with here,
All right.
it says we insure the legal representative of the deceased. So we can infer that once there's no more legal representative of the deceased, then you don't get the benefit of the death clause anymore. And here, legal representative means the executor of the estate, or the person who's in charge of the probate proceeding and distributing the assets. So in other words, once that proceeding is finalized and the assets get distributed, there's no more legal representative, so there's no more coverage under the death clause. Now, more and more, I am seeing companies put a 180-day cap also into the policy in the death clause. So you get 180 days, about 6 months, but in those policies, no more than that. And I think that's sensible because sometimes these probate proceedings really drag on, whether it be because there's a family fight or just there's no one really pushing it forward. And you don't want coverage to go on indefinitely forever. So providing that hard stop is probably a good idea.
I'm with you, Tim, because look at it from my perspective, being the policyholder advocate. I'm going to say once an executor of an estate, always the executor. Just even though it went through a court proceeding or something, I was still the executor of my father's estate. So how dare you tell me that I don't have any coverage for this thing?
Right. There's numerous cases, though, where the probate proceeding ended, the assets got distributed, that argument was raised, and courts, for whatever reason in this area, courts they've not really been listening so much to the fairness arguments, and they've just gone with, this is what the policy says, you don't have coverage under this policy. And these they tend to get litigated more than, the little tree removal claims of $200. These can be big claims. So they're going to go to court all the way, and you will get court opinions on this.
May I ask a follow-up question?
Yep.
But since I'm old, I forgot already what my follow-up question was, but it'll come to me. So we have the lady. Oh, there was part in there in that clause that you wrote that we would still cover the property almost, and I'll paraphrase, as it existed at the time of the death.
Yeah, and I cut out part 2 of the clause here.
Okay. where it's going to destroy my argument, is that
it expands the definition of insured to people who were insureds at the time of the death.
Okay. And she did not live at the home at the time, so there's no way she could backdoor in. I wasn't insured.
Correct.
Okay.
Correct.
And do the conditions of the policy then apply to that legal representative? I assume,
Ooh.
you have to keep paying the premium, maybe out of the estate or something. You can't just stop paying the premium, stop cooperating. I mean, that seems common sense to me, but I don't know if it's in there.
Yeah, good question. From my memory, there is one case where it was about the duty to maintain heat in your building, and so to avoid frozen pipe losses. And again, to my recollection, I believe the court said yes, the legal representative standing in as the you named insured in the policy did have a duty to maintain heat in order to avoid that frozen plumbing exclusion. And to your point, Brennan, it just makes sense. Someone needs to do all those things on the policyholder side of this, so it should be the legal representative, because they, on behalf of the estate, are the ones getting the benefit of the coverage.
Can I throw out another thing there, Tim, that may or may not be fair? But I'm just curious, let's say I'm the insurance company and or the agent. All right, now, the insurance company under any obligation to like underwrite? So I can look at the age of my insured and say, it says here this gentleman is now 104 years old. Might I contact the agent and say, hey, have you talked to Mr. Insured recently? He still out there? Seems like the premiums are coming in. But is there any obligation from the insurance agent or the insurance company to like underwrite to make sure this gentleman is still with us on this side of the earth?
From the company perspective, probably not. It would be more of a business practice. If they wanted to do that, they certainly could. But I know just as the matter of business practices, a lot of companies do like the auto renewals. And, there's one case from Ohio where there was an obituary published in the newspaper. And the argument was,
Oh, wow.
well, insurance company, you should have known that my policyholder was no longer living because it was in the obituary. And the court rejected that argument and said pretty plainly, no, the insurance company doesn't have to go out and find
Monitor every
information out there and try to monitor it. It's more on the policyholder or the person who wants to be covered to notify the insurer of the new situation so we can get things sorted out.
So
Might I stop you there, Brendan, before you jump in? No, I'm sorry I apologize for jumping in.
No.
But what state did you mention, Tim?
That was Ohio.
Oh, OH.
Oh,
Io.
state.
Yay. Thanks, Brendan. All right. I'm sorry. I digress.
But no, in this case, did the daughter do anything at all to indicate that the father had passed away? Like, was there, maybe just told someone verbally or put her name on all the stuff, but didn't actually do the effort to make the official change? Or was the insurance company totally in the dark about what happened?
Here, we're going to say the insurance company was totally in the dark.
Wow. Okay.
And it does go to, like Mike was saying, well, how does the renewal process work? And sometimes, probably not with the 100-year-old, but sometimes there's going to be a mortgage on the house.
Yeah.
And I know I pay my mortgage every month. I don't pay the insurance company. I pay the mortgage company, and the mortgage company pays the insurance company. So it's even one step further removed that if you're an insured, you have to really think to and know to contact your insurance company and make sure the right name is on the policy. Are most insureds going to know that? I don't know.
Yeah, I mean, if you're, conversant with the policy or reading the policy, hey, you see all that you language, that's really present to mind to us in the industry. But if you're not in the industry, you think it's the house,
Right.
the house changed, we're paying the premiums,
Still
to a
insured.
layperson, it might not, it might make sense to, why would I need to change the name? It's the same house.
Right. I agree with Brendan again.
So is there anything they can do, or are they just totally out of luck here?
Okay, well, like I said, this has been tested in court numerous times because, if your whole house burns down, you're going to press that one all the way. So we do have some examples here. If I'm a policyholder, I'm going to Mike's. All right, you know what? I'll hire Mike as my attorney to get up there and practice law without a license in court for me and say, this is not fair.
I'm known to do that.
Fundamentally unfair. This daughter, she had no idea. She acted in good faith. We can't let her just lose the entire value of her house. She paid premiums every single time. Now, this argument has gone pretty much nowhere in court.
Wow.
It would have to rely on a judge, and they do this all the time, that if they sense some unfairness, they'll find a doctrine somewhere, and they'll use it to rewrite that contract.
Yep.
So here you could think of, the first thing I would think of is like a mutual mistake doctrine, where if two parties both are mistaken about the same fact, we'll rewrite it. But then when you think about it, the mistaken fact, the insurance company did not know that the father was dead. The daughter did know that the father was dead. So that's a unilateral mistake. Can't use the mutual mistake doctrine. The next thing I would think of is like a waiver or estoppel thing. But this would really depend on the insurance company knowing that the father was no longer living and then going ahead and assenting to continue with the policy. But if they didn't know, then you can't really use that one. Same thing with like an implied contract theory. They would have to know what they're doing. But if the daughter never told them, then Yeah, I don't know. It's hard. There was probably 4 or 5 cases on this where the court held against coverage, and all of those have been tried before. Mike, here's the Ohio case.
All right. Yay.
Called Ramsey versus Allstate. And all these cases, you, of course, can find on plrb.org.
Awesome.
In this case, they tried to use the implied contract theory. The court said, okay, fine, but only if you can prove that the insurance company knew that the father died. And it wasn't looking too likely that that was going to happen. Then we have a case from Michigan where the court held a renewal policy issued after the insured's death was not valid because the offer to renew was only made to the deceased, and hence not a valid offer, not a valid contract going forward. Then we have a case from Pennsylvania. This one is interesting because, well, the court held that, and this goes kind of against what we were saying before, is some people think insurance is on the house. The court here specifically said, no, insurance is for a person, not a house. It's a personal interest. So if the person is no longer living, we can't cover it under this policy. There was a concurring justice or a concurring opinion in this case that noted the outcome of this case was harsh, given that the decedent's daughter had sent a check to the insurer for coverage during this time period, and she believed that the property was insured. However, either the Supreme Court or the Pennsylvania legislature would have to change the law to provide coverage under these circumstances. So they kind of said, as a court, our hands are tied by that contract.
It does kind of go back to one of the core concepts of insurance, which is somebody has to have an insurable interest in the home. So I don't know that the daughter does. I mean, she's living there maybe, but it was still a contract between the named insured, who was the dad, and the insurance carrier. So yes, it kind of makes sense. But can I jump on my soapbox for a minute, Tim and Brendan?
Sure.
Yeah.
Because I'm an older gentleman. And you two youngsters out there, when you're out there shopping for your insurance, you're probably out on the internets, the thing that I hear about all the time. And well, I'll do this by myself and I'll just find the best rate. And there I go. It might make sense every now and again to involve yourself with an agent and then contact that agent. Like my good old agent, every year we get together, make sure nothing's changed, everything good on the contract. Maybe they're just calling to make sure I'm still alive. I don't know. Maybe that's their friendly way. But anyways, we do a policy review. Everything okay? So again, a shout out to your agent, either captive or independent. That's fine with me. It's America. Go with what you like. But if you're out there doing it yourself, it just like you said, Tim, when I was acting as my own attorney, what did they say about somebody who's acting as their own attorney? Something as a fool for a client, something like that. So maybe involve your independent agent and or captive agent and or agent in general. Who cares? Broker, whoever it is, somebody out there that's working on your behalf to check into some of this stuff. Make sure you're properly insured and covered so we don't have to use you as a scenario. And what's the scenario with PLRB? All right, I'm off my soapbox. Thank you so much.
All right. I think that's a good moment to turn to Tim and say, so Tim, what can we take away from this scenario?
Hey, let's recap. The named insured passed away, house inherited by his daughter, who then moved in, but didn't change the name on the policy. After the death clause has expired, which it did, the policy arguably no longer provides coverage unless the insurance company knew about the death and yet agreed to continue with the policy as is. Otherwise, the insured would have to convince a court to reform the contract, and those types of arguments have so far met with very little success in courts. So, Mike, if an adjuster wants to learn more about the death condition and contract reformation and all of these great and wonderful legal issues, where could they go?
Well, of course, they can head out to, as you referenced, our fabulous PLRB website, plrb.org. Check out all those cool coverage questions and answers that you referenced. The case in OHIO, Ohio, and PA, and I don't know, you mentioned Michigan. There's lots of cases, so you could search on the death penalty, the death clause in your policy, and I bet you're going to get all sorts of information. Or if you ever stumble, say, geez, I just can't find what I'm looking for. You could also reach out, ask a coverage question. Some knowledgeable person at PLRB, much like Tim, will reach out to you with a wonderful answer and help you answer the questions that you may have. Brennan, would you be kind enough to share this type of information in there and around at the show notes somewhere?
Yes, and there you'll also find a recap of the key points from this episode and links to our social media. Don't forget to subscribe and rate us and give us a call at 630-509-8704 and leave a voicemail to share your adjuster story. We'll see you next time.
Yay. Bye, everybody.
Bye. The views and opinions expressed in this resource are those of the individual speaker and not necessarily those of the Property and Liability Resource Bureau, its membership, or any organization with which the presenter is employed or affiliated. The information, ideas, and opinions are presented as information only and not as legal advice or offers of representation. Individual policy language and state laws vary, and listeners should rely on guidance from their companies and counsel as appropriate.